I beg your pardon. What we're talking about today. You may have seen in the news that one of President Biden's last acts has been to pardon his son Hunter Biden over certain firearms and tax charges. So what I thought I would like to do is discuss how that happens in the US, but then also relate back to the history of royal pardons and now executive pardons. I mean, technically they're still royal pardons, because, you know, that's where it sort of derives from. But first of all, how has President Biden been able to do this? Well, the US Constitution, Article 2, Section 2, Clause 1 states, "The President shall have power to grant reprieves and pardons for offences against the United States, except in cases of impeachment." So what does that mean? Offences against the United States, that means these are pardons for federal offences, because the way the US government works, obviously you have the individual states and commonwealths and territories that have their own legal systems, but then there's also a federal legal system. Now, just to go off at a tangent, because I know you like these sorts of things, the phrase politically correct originates actually with American jurisprudence. And what it originally meant was, just as it, you know, the word said, as it sounds, have you got the politics correct? So one example was the Supreme Court would say, there's no such thing as a national government. That is politically incorrect. The politically correct is, it is a federal government. So the president can only actually pardon for federal offences. There is a mechanism for state offences to be pardoned, but that's done through, say, the relevant governor of that state. So when at Thanksgiving, when the president does that sort of, I will pardon one of the turkeys, which is also a bit cruel, because it's like, it's like the Hunger Games for turkeys. It's like, you've made it, but you haven't. But those turkeys could still be prosecuted for state offences. What's the impeachment thing? Impeachment is the process where in Congress and then the Senate, they have a power to effectively control their own processes and prosecute their own members, people, government officials. And you may remember Trump actually was impeached twice. But to be impeached is just effectively to have the charges laid against you. And Congress votes on that, and it's a simple majority. Should we impeach this person? But then in order to find that person guilty, you actually need a majority, a supermajority, at least 60% in the Senate. And obviously, as they're very split on party lines, fairly evenly down the middle, that's why, although Trump was impeached, he was never actually, quotes, convicted. A pardon, because there's not just a power to say you never did it. There are various things that the president can do. A pardon, that's an executive order granting clemency for a conviction. May be granted at any time after the commission of the crime, and we'll come on to, can it be done before a crime? You can actually apply to be pardoned, but you've got to do it within 5 years of the sentence being completed. There's also a reprieve. That's a temporary postponement of a penalty. So like, you've been convicted, but I'm going to grant you a reprieve. So if you keep your nose clean for a certain amount of time, then we'll see what happens after that. And there's also a commutation. That is where you reduce the sentence. This happens a lot in death penalty cases. I will pardon you. I will commute your sentence as the president, so you're not executed. But I will impose, a life sentence or something in lieu of that. But how did this start? Well, over here, it's all to do with what we call the royal prerogative of mercy. And that's a very ancient power, because especially when, the monarchs were quite literally a law unto themselves, they could do anything. I mean, without going and expanding too much, this is how we ended up with, the courts of equity and now equitable principles. I mean, I've done other videos on that, which you can search for. But it always used to be that if you were unhappy with how a common law, the common law courts had dealt with your case. And this wasn't just for criminal cases, this was for civil cases as well. You could appeal to the Lord Chancellor as the conscience of the king. And the Lord Chancellor would take a look, and if they thought that the outcome had been unjust, then they could actually give you a different remedy. I mean, the problem there is people said, that equity it varies with the length of the Chancellor's foot. In other words, it was all a bit random, because the argument for the common law is it provides certainty. It might not always give you a fair result, but it gives you a predictable result. Because, here's the rules, and if we apply the rules properly, this is the outcome. Sometimes, of course, that might produce an injustice. So in equity, they say, well, let's just look at the facts. What should the outcome actually be from a matter of fairness? But who decides what is fair? Well, it's just the Lord Chancellor. I mean, now, since the Judicature Acts in the 1870s, the separate courts of equity have vanished, but courts can still use equitable remedies. Because, to get back to civil, in common law, the only remedy available is damages. That's the only thing you can get. But what if you want an order for your property to be restored? Or you want an order saying, could you stop doing this? They're a type of injunction, and injunctions are an equitable remedy. Equity crops up a lot in sort of complex housing and financial litigation, where it's, well, on the law, as the law applies, this house belongs to this person, because they've got the legal title to it. But what if actually they've been working very hard? They've been promised the farm. I mean, this will come up a lot with all the tax things, but if you work for me for effectively nothing because you're a family member, I'll leave the farm to you, and then they don't. The will says no. Well, in common law, it's tough, but an equitable remedy can be, well, I don't care who you've actually left this to in your will. It's not fair if the person who thought they were going to inherit this and effectively worked for free doesn't get something out of it. So an equitable remedy is to say, okay, either we give you the farm, or, okay, the person can inherit the farm under the will, but they must pay some compensation back to the person who was promised the farm. Now, it's been used since at least 1617, the royal prerogative, but in a sort of formal fashion. But kings have always been able to let their mates off. Now, however, the royal prerogative is exercised by the executive. I mean, that happens for lots of things. I mean, it's always been a matter, it's the royal prerogative to go to war. But now, of course, the executive decides whether or not we go to war or not. And there are various ministers who can effectively argue and say, recommend to the king a pardon. So that's the Secretary of State for Justice, Secretary of State for Defence, Lieutenant Governor of the Isle of Man, because, of course, their position within the UK Constitution is a bit complex. Scottish ministers can recommend, and the Secretary of State for Northern Ireland and devolved matters. Also, Commonwealth countries, they can apply. People from Commonwealth countries can apply. And in those cases, it's usually the Governor-General who makes the recommendation. One thing that's interesting is, when Derek Bentley was pardoned, the let him have it Chris guy, the court there said, this is actually, well, probably, to quote them, a matter of policy rather than law. It's a political decision, and thus it's not justicable. In other words, it can't be appealed or it can't be challenged because it's not a legal procedure. We have different types of pardons. We have free pardons. That's where somebody is, there's no consequence for what they did. There's absolutely no penalty. But the thing to remember about a pardon is it doesn't expunge the original conviction. You are still, as far as the law is concerned, a convicted criminal. It's just that there is, no consequence of that. So, pardons, we don't have them as much now because we've got, the appeal court. You can appeal to the Supreme Court, and also since the Criminal Cases Review Commission has come on board, that effectively, because it can recommend back to the Court of Appeal, who can then quash the conviction anyway, that is much more common procedure now than actual pardons, because of course, if your appeal succeeds in the Court of Appeal after being referred by the CCRC, then that expunges the conviction as well. You are, as far as they are concerned, you are factually innocent, as well as somebody who is not facing the consequence. There are conditional pardons. That's a bit like the US equivalent of remission, where it just substitutes one penalty for another. So again, the very common one there was, the conditional pardon is, you won't face the death penalty, but you'll face the life sentence or something like that. I mean, you can actually pardon you posthumously. Again, Derek Bentley was. It says, congratulations, we shouldn't have hanged you. So that penalty was wrong. Whether or not that actually makes much difference to him, who knows? And there's also things called special remissions, sometimes called remission pardons. They reduce the effect of a sentence. And that's more, we will release you early, or something like that. I mean, that'd be so interesting. There was one there, actually, where it was a couple of guys serving quite prison sentences, and they actually, one of the, I think it was the assistant governor, or somebody. It's very weird with prisons now, because you don't just have one governor. Governor is a rank as well as a job description, so you can have multiple governors in prison. But he was attacked by a wild boar or something in the prison garden. Don't know how that happened. And they helped him and rescued him and suffered some injuries themselves. So actually they got, okay, do you know what? We're going to let you go early. Because, fair enough, social balance sheet, yes, you know, you were doing your time, but you put yourself at risk for one of the, I nearly said one of the screws there. And by the way, we call them screws, supposedly, because they used to turn either the thumb screw, probably not that, but when they had to do that thing where they would walk on a big wheel all day, like a big treadmill, they could turn the screw, remember that phrase, and make it harder to walk. So that's why we get that from. They actually, pardons, there's about 6 a year now in the UK still. I don't know how many there are sort of Commonwealth, because I mean, for once I've actually done a tiny little bit of research for this, unlike my usual, what can I remember about this from chatting at the pub? But anyway, that's how it happened over here. So back in America, when they were writing the Constitution, and in all fairness, when they were writing the Constitution, I mentioned in my other video about Middle Temple, the Constitution was pretty much written by English lawyers. So it's perhaps unsurprising that there's a lot of English law crept in there, and that's why there is that pardon power within the Constitution. Some people actually did object to this. You know, they said it gave too much power to the president, because it's basically, he could just let all his mates off. And, you know, you can still see the argument. I mean, I suspect we'll be having this argument today, now. And I suspect if you do social media or the news, there's probably going to be lots of discussion about the actual history of the pardons. So, as I said, the president could only pardon for federal offences. Now, the interesting thing about a pardon is, it's effectively a deed. And the thing with a deed is, the recipient generally has to agree to it. You can refuse a pardon. You can say, you know, we're going to pardon you. No, I don't want to be pardoned. I mean, I can't find any historic... Oh, actually, yeah. And Andrew Jackson pardoned somebody called George Wilson, who was... Yes, because he robbed the Federal Mail. And he actually refused the pardon, because he was arguing, I'm not accepting the pardon because I say I didn't do it. So you pardoning me, because by definition accepting the pardon, the argument is because it just gets rid of the sentence, you're accepting you were guilty. So he actually said, no, I'm not going to affect it. If you are pardoned, all those things that apply when you're convicted as a federal felon go away. So you can vote again, you can buy, you can own firearms and all that sorts of things. So that's quite handy. Now, can people pardon themselves? Can a president pardon themselves? Well, it's very interesting that. I mean, the situation's never occurred, but people were discussing it in relation to Donald Trump. But this all crops up, after Watergate, and there was the argument, could Nixon pardon himself? Now, what happened there, of course, is that Nixon resigned, and Gerald Ford pardoned him. They pardoned him for, like, all offences, past, present and future. I mean, if I was Richard Nixon, I'd go, cheers for that, and just go out shoplifting. But, that was how they got round that. But at the time, there's lots of discussion as to whether or not Nixon could have pardoned himself. And it gets into lots of constitutional issues. I mean, some people said, no, the president has this absolute unfettered power within the Constitution. There's nothing there that says it limits it. But then other people are saying, well, general legal principles, you can't be a judge in your own case, so therefore the president can't do it. So it is a sort of pretty controversial issue. But there's no disputing that Biden had the power to pardon Hunter Biden. So there's no challenge there. Nobody can rush off to the courts and challenge this, because in the same way that you can't challenge a royal pardon or a pardon executed under the royal prerogative via the executive, it's probably very much going to be the same thing there. I mean, since the case of Mayberry and Madison, that's the case where the Supreme Court came in and said, we have an absolute veto to judicially review any act of the government. And it's like, well, okay. I mean, that was the court pretty much extending its own powers, because originally, you know, the US Supreme Court, arguably, you know, the government was the most powerful body and the court was just there in the same way as in England. That it can review legislation and make sure the government is acting in accordance with its own legislation, but the government can legislate to do whatever it wants. So if it's not happy with a court decision, it can pass a piece of legislation saying, ignore what the court said, this is the law. It's a lot harder to do that in the US because they have their sort of written constitution, and the courts interpret that in a way that says they can actually strike down primary legislation, which is a very, very rare thing for the UK, and it is correct to say UK there, Supreme Court to do. So there you go. So that's it. So that's a history. And whenever he's talking about on social media, there's a bit of chip in with all these fascinating facts. Oh, there was actually I made a note of this somewhere, because there was actually an interesting one after our Civil War. You know, the Roundheads and Cavaliers one, where there was an act of oblivion that basically pardoned anybody for any acts that occurred during the Civil War, with a couple of exceptions, such as regicide. So they didn't pardon the people who had Charles I executed. Interestingly, that wasn't a trial. The one thing that even the government, you know, the revolutionary government recognised was that they didn't have a power to put the king on trial, because all prosecutions, even private ones, were brought in the name of the king. So actually they created a sort of a special court within Parliament. But Charles was actually dealt with under effectively what we call an Act of Attainder, or a Bill of Attainder. A Bill of Attainder is where Parliament just passes law saying, as a matter, you know, because, you know, when they state the law, they can say anything they want in the law, you know. As a matter of law, a child is 18, whereas a child used to be 21. So, you know, Parliament can just pass anything and said, as a matter of law, we find King Charles I, well, it'd just been King Charles then, wouldn't he? King Charles is guilty of these offences, and he is to be dealt with in this particular way. Now, that's a very wide-ranging power, but the government over here can do that. They can pass bills of attainder. Churchill wanted to do that after the end of the war. He said, we just pass a bill of attainder against all the Nazis and just, you know, deal with them rather preemptively, you know, in a rather quick fashion. It was actually Stalin who said, no, we want a big show trial about this so that the world can see what went on. So that's obviously, you know, a very powerful thing. I mean, but it used to be like divorces were like that. If you wanted to divorce, you had to get a private member's bill through Parliament saying, as a matter of law, Mr. and Mrs. Smith are now divorced. Interestingly, when the US Constitution was being drafted, the English lawyers said, no way. So actually, bills of attainder are expressly prohibited in the US Constitution. So to summarise, the President pretty much has a power to let anybody off of an offence, but what the President cannot do is say somebody is guilty of an offence. So that's quite a nice roundup anyway. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. I am now back. Sorry for the gap, but I was away doing the ASDA training for the young pupils. We had a massive bunch of them, and we were allowed to use Bristol Crown Court, so we made them all robe up and everything, and we sat on the bench, although we didn't bother, because it's like, look, we're giving up our time here, so we were just all in our scruff. But I just love doing that because it's so nice to pick up on their enthusiasm. You know, they come along and they just work so hard and they really put their hearts and souls into it. And they all start off all really nervous at the first, you know. And we all say, look, you know, chill, enjoy, relax. Yes, of course, you are being graded on this and marked and you have to pass it. But, you know, you can't really say, look, we're pretty chill about this. Don't worry about it. But the actual standard from when they start, the first time they start, they're all like really nervous on their feet. And then when they get into it and they're all of a sudden they've turned into sort of like George Carman. It's wonderful to see. And also, one of the reasons I do it is it really ups your own advocacy game. Because you're meant to be demonstrating excellence in advocacy. Part of the procedure is we then say, now watch how I do it. And usually I make a complete ass of it. But as I've always said, it's better to be a horrible warning than a shining example. Oh, and I'm just going to move. I always get the side wrong. Right, YouTube puts the thing there, so I want to be at that side. There we go. I look like that. I look like I'm contemplating a pardon, or I'm on the, I'm on the receiving end of a pardon. I mean, I don't know about you, but if I was Baron Trump now, I would literally be out, sort of robbing post offices.